Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Rahul Gupta. He graduated his law from J Law College in the year 2024. He practices in civil and commercial litigation. Today he is going to speak on Homebuyer's dilemma when builders go bankrupt. So without wasting further time, I would request Advocate Rahul to commence with his lecture. Thank you.
Ladies and gentlemen, before I begin, I would like to extend my sincere gratitude to INN's Advocates Hammurabi Tablet for giving such an amazing platform to young professionals like me to speak about interesting legal points and so on. With that, I, Rahul Gupta, am here to shed a light on a critical and an ongoing challenge, that is the home buyer's dilemma when builders go bankrupt. So before I begin, I would also like to shed a light on a crucial fact that everyone here has always dreamt of buying a home. Whenever you start working, you always imagine of buying yourself a nice lavish home. You start saving money, you start exploring your style, your wants, your desires, and then one day, finally, you have the right amount of money to buy your desired home. You get in contact with a good builder, good developer who has a reputed name. You get in touch with good interior decorators and finally go to a bank, take a loan and book a flat. Everything is going smoothly. Now one fine day, you get a call, you get a notification stating that the developer with whom you had booked the flat has now gone bankrupt. Your project has stalled. Now the possession which you were to get 5 years later has now maybe extended to 10 years later or more. You never know. What are you going to do? You don't know. You are simply going to pay monthly installments for nothing. Banks would be behind you. Pay the monthly EMI, clear the loan, but for what? All your dreams, all your aspirations have just shattered. You have nothing left now. So does that mean everything is gone? No. So here I am today going to give you some remedies, some recourse through which you can come out of this whirlpool. For this very thing, there has been an enactment of an authority known as Real Estate Regulatory Authority, which was established in 2016. Now, RERA was basically established for bringing transparency, accountability, and discipline in the real estate sector. Before its enactment, home buyers had little to no legal protection against project delays, fund mismanagement, or fraudulent developers. Now, RERA was introduced just for this fact. Under RERA, every real estate project must be registered with the state regulatory authority. This ensures that developers cannot advertise, sell, or accept money from buyers unless and until they meet stringent compliances. One of the most important factors being that the funds, that is 70% of the funds collected from the buyers must be kept in an escrow account, which would drastically reduce fund mismanagement. Now under RERA, the home buyers were also empowered to file complaints against developers due to project delays, false advertising or poor construction, from where they could claim refunds, compensation or possession of their property. Under this act, there were two tribunals established. One was RERA Tribunal, and if there is an appeal, RERA Appellate Tribunal. But still, it still doesn't answer the question what happens when builders go bankrupt. What happens when a bankruptcy process is initiated against the builder? Now, subsequently, right beside RERA, there was another law which was established, which was Insolvency and Bankruptcy Code of 2016. That enabled the builders to go into the bankruptcy process. So basically, if you all know, when builders or developers decide to develop a building, a society, they also take loans from banks or financial institutions, and if they fail to repay that amount, that loan, banks and these financial institutions are within their right to initiate corporate insolvency resolution process against these builders and developers. But what about the common home buyers who have bought their flats in these societies, in these buildings, and these builders have gone into this process? When a bankruptcy process or an insolvency process has been initiated against a builder or developer, their project is stalled, halted for the time. There's a moratorium imposed which restricts even the home buyers from initiating any proceeding against that developer company, against that builder before RERA. So what can they do now? They cannot go before RERA, which was established for this very reason. But now the builder has gone into bankruptcy. That proceeding is going on before different forum. For this very reason, to curb this very reason, in 2018, there came an amendment in the Insolvency and Bankruptcy Code which made it possible for home buyers to be present, to be included in the bankruptcy process. This amendment made it clear that even the home buyers would be considered as financial creditors in the insolvency process, and they can initiate CIRP process, that is corporate insolvency resolution process, against this developer or builder company, or they can file their claims to get their money out of this entire process, and they be included in the key decision making process and give their votes in the resolution plan and get their desired outcome. This thing was later even upheld, this amendment was later also upheld by the Honorable Supreme Court in the judgment of Pioneer Urban Land and Infrastructure Limited and another versus Union of India, wherein it upheld the constitutional validity of 2018 amendment, thereby confirming the home buyer's right as financial creditors in the insolvency and bankruptcy process. Now, by including them in the process was not without some issues. Basically, what happened was the home buyers started filing frivolous complaints against builders, developers to get more money. And for this very reason, there came another amendment in 2020 which introduced a threshold requirement for the home buyers to initiate CIRP process against a developer, that being at least 100 home buyers or 10% of the allottees in that project to initiate CIRP process of a CIRP process against the developer. Judicial intervention has been a game changer in protecting home buyers, ensuring that they are no longer at the mercy of developers or financial institutions. The Supreme Court has repeatedly emphasized that home buyers are not just consumers but crucial stakeholders in the real estate projects, deserving a say in how insolvency process unfolds. Recognizing the vulnerability of home buyers, the court ruled that they must be given the same rights as financial creditors, allowing them to actively participate in a decision-making process and ensuring that their hard-earned money is not lost due to a builder's financial mismanagement. However, despite these rulings, there have been delays in insolvency proceedings. In many cases, the developers misuse legal loopholes to delay proceedings, leaving the home buyers in a limbo. This is why the latest 2025 amendment in the insolvency and bankruptcy process is crucial. The 2025 amendment introduces several significant changes aimed at enhancing home buyer protections within the insolvency proceedings. One of the most notable provisions is Regulation 4E, which allows resolution professionals to facilitate possession handover and property registration if 66% of COC approves. This ensures that home buyers can take possession of their apartments without unnecessary delays, even if the insolvency proceedings are ongoing. Additionally, Regulation 16C also permits the appointment of facilitators in cases where a project has more than 1,000 creditors, ensuring that home buyers receive timely updates and clear communication from resolution professional. Another crucial reform is the inclusion of RERA authorities in COC meetings, ensuring that RERA's regulatory insights are considered when formulating resolution plans. Lastly, the amendment also strengthens the transparency and reporting obligations, requiring RPs to submit detailed progress reports on project status and funds utilization and pending approvals so that home buyers remain well informed throughout the resolution process. Now, these changes represent a major step forward in balancing the interests of home buyers and ensuring quicker, fairer resolutions in real estate insolvency processes. Now, after all is said and done, there must also be some protective measures to be taken from the home buyer itself. Let's dive into them. Now, home buyers must adopt practical and proactive measures to safeguard their interests and avoid falling victim to fraud, delays, or insolvency related issues. The first step is thorough due diligence. Yes, before investing in a project, buyers must verify whether the developer is first RERA registered, check if its past project completion records are correct, and also review their financial stability, such as do they have a loan default or do they have pending litigations. Home buyers should also scrutinize agreements very carefully, ensuring that contractual terms specify what are the possession timelines, what are the penalty clauses if there is a delay, and refund policies in case of project abandonment. Opting for projects wherein it has been specifically specified that 70% of the buyer funds are secured in the escrow accounts, which has been mandated and made compulsory by RERA. Now, even after a purchase, vigilance is the key for home buyers. Home buyers should actively track project progress through RERA websites, attend builder meetings, and engage in home buyer associations to collectively raise concerns. In case there are delays, they must immediately file complaints against under RERA, seeking either compensation, possession, or refunds with interest. And if it is a situation wherein insolvency proceedings have begun against the builder, home buyers should quickly gather a minimum 100 members or 10% of the total allottees in a project to meet the IBC threshold or for initiating its claim in the entire CIRB process of the builder. Once the insolvency proceedings have commenced, they must participate in COC meetings, should actively be involved in the voting process of the resolution plan, and ensure that the projects are completed rather than liquidated. Home buyers should also diversify their legal approach. Instead of relying solely on IBC or RERA, they can also approach consumer forums for deficiency of services or file breach of contract terms against the developer himself. Now, I want to make this clear. I know I said that the moratorium had been imposed, but that has been imposed against the developer company itself and not against their individual directors. So, the home buyers are well within their rights to submit or file any claim or any case against these individual directors before a consumer forum or against RERA or against any civil court. Finally, staying updated is very crucial to the home buyers on legal changes they should immediately seek expert legal advice and ensure compliance with all documentation formalities. By taking preemptive steps, staying vigilant, and leveraging multiple legal remedies, homebuyers can effectively minimize risks and safeguard their investments in unpredictable real estate market. After safeguarding their position, as per me, there can be some new changes in the existing legal framework. A crucial step would be to begin with enhancing coordination between IBC and RERA. While 2025 amendment has included RERA authorities in COC meetings, a stronger mechanism is needed to ensure that RERA and IBC can go hand in hand. Now, fast tracking real estate insolvency cases and strict deadlines for resolution professionals should also be implemented so that the long drawn legal battle for the home buyers is restricted to a minimum. Even technology can also play a transformative role in home buyer protection. There could be an implementation of implementing blockchain based land registries, AI driven fraud detection systems, which would in turn help in eliminating fraudulent property sales, track fund movements, and ensure project accountability. Governments and regulatory bodies should also focus on stronger penalties for non-compliant developers, ensuring that financial mismanagement, misrepresentation, and willful delays result in legal and financial repercussions. Finally, educating home buyers about their rights, legal remedies, and risk mitigation strategies is crucial for long-term protection. A well-informed buyer is less likely to fall victim to fraudulent practices and is better equipped to take swift legal action when needed. With continuous legal reforms, improved enforcement, and the integration of advanced technology, I believe the future of homebuyer protections will be the one that is more transparent, consumer friendly, and legally robust, ensuring that the homebuyers' investments and dreams remain safeguarded in an evolving real estate landscape. The journey towards real estate homebuyer protection is ongoing. With RERA, IBC, and other strong judicial precedents, homebuyers today are, I can surely say, in a far better position than before. However, knowledge is still power. The more we are aware of our rights, the stronger we become in holding developers accountable. By working together and advocating for continued reforms, we can very well create a system where home buyers are not just protected but also empowered. Thank you.
Rahul, thank you very much. It was nice to hear overall protective shield which we have proposed to the home buyers, because this is one of the major dilemmas which is there as on today. So a nice overview you had given of RERA, nice overview you gave of IB, and you have also given your own suggestions that you think certain new things should happen to solve this problem in a nice manner. Thank you very much. A small token from Hammurabi to you.
Thank you so much.